Good afternoon, folks. This afternoon's topic D discusses the United Kingdom's assisted dying law. So we'll get into that in a minute. Please join me for the presentation I made for you. We will get going in a few minutes. Okay, guys. The Politics Co UK report describes a growing cross-party backlash against a proposed alteration to the UK assisted dying bill. An alteration that critics say would significantly dilute one of the bill's most important safeguards. The original draft required every assisted dying request to receive High Court approval, ensuring an independent judicial check before life-ending medication could be prescribed. A new amendment, however, would replace that judicial oversight with an expert panel chaired by a legal professional. Supporters frame this as a practical improvement. Opponents argue it's a quiet but consequential weakening of protections for vulnerable people, and potentially a breach of the political trust that enabled the bill to pass its second reading. What the proposed change is: the original safeguard, every application for assisted dying after being approved by 2 independent doctors would go before a high court judge. This judicial stop was widely seen as a cornerstone of the bill's safety architecture. Proposed amendment. MP Kim Leadbeater has suggested replacing the High Court's requirements with an expert panel. The panel would be chaired by a legally qualified professional. It would include clinical and ethical experts. It would review cases already approved by 2 doctors, effectively becoming the final gatekeeper. The shift moves the decision from a formal judicial setting to a specialist administrative one. Arguments in favor of the change. Supporters of the amendment present it as a pragmatic refinement, not a weakening. Effectiveness and timelessness. They argue that routing every case through the High Court could create delays for people who are terminally ill and may not have only weeks or days left. A panel could act more quickly, reducing bureaucratic bottlenecks. Specialist scrutiny. Proponents say a panel composed of clinician ethics and legal experts may actually provide more relevant expertise than the single judge who may not have medical or end-of-life experience. Public accountability. They emphasize that panel appointments would be transparent, regulated, and subject to public procedures, countering claims that the process would become opaque. In the framing, the panel is not a shortcut, but a more tailored safeguard. Arguments against the change. Critics from multiple parties, some of whom supported the bill at second reading, say the amendment is deeply troubling. Loss of judicial independence. The High Court requirement was a major reason some MPs felt comfortable supporting the bill. Removing it, they argue, steps away the most impartial and authoritative safeguard. The entire framework, risk of private, less adversarial decision making. A panel could meet behind closed doors without the procedural rigor, transparency, or adversarial challenge that courts provide. Critics fear this could lead to decisions that are less robustly tested. Concerns about bias. Some MPs Some MPs warned that panel members might be drawn from circles already sympathetic to assisted dying. Creating a self-selecting group rather than a neutral arbiter. Political trust and process. Several MPs say they voted for the bill on the understanding that judicial oversight was not negotiable. Changing that now feels to them like stiffening the goalposts mid-debate. For these critics, the amendment is not a technical tweak, it's a material weakening of protections for vulnerable people. Political and practical implications. The controversy has quickly become a flashpoint in the bill's progression. The amendment has triggered cross-party concern, suggesting the bill's coalition of support may be more fragile than it appeared. The judge versus panel question is likely to dominate the committee stage and could shape the bill's fate in later votes. Public confidence in the bill's safety mechanisms may hinge on how this issue is resolved, since judicial oversight is widely perceived as a gold standard safeguard. In short, this is not a minor procedural debate. It's a defining question about how the UK chooses to regulate one of the most ethically sensitive decisions a person can make. Where to look next? As the bill moves forward, the most important details to watch will be how the panel would be appointed, what transparency requirements would apply. Whether there would be an appeals process, how independence and importantly impartiality would be guaranteed. These specifics will determine whether the panel becomes a credible safeguard or whether critics' fears of weakened protections prove justified. Okay, if you want, we can also compare this safeguard debate to those in other judications, jurisdictions like Oregon, Canada, or New Zealand to see how different systems balance autonomy and protection. Okay, guys, that is D for you. I will see if I can do an E. I'm going to take a little break and do maybe come back on and do an E for you. For now, Gator Wellness. Take care, folks.